Hi there, Doc from Barcast Audio here, today to talk with you about the rule for false imprisonment as tested in law school and on the bar exam. Before we get started, be sure to subscribe to this channel for more of these videos. Be sure to check us out at barcastaudio.com for audio outlines, essay attack sheets, whatever you may need to pass the bar exam or your next law school exam, we have it for you. Check us out at barcastaudio.com. So false imprisonment is one of our intentional torts, and we're here just going to be talking about the general rule and some examples of what false imprisonment is and what it is not. So the general rule to remember for false imprisonment is as follows. A false imprisonment is established by a showing that a defendant, 1, intentionally, 2, constrains a person to a bounded area of which there is no reasonable means of escape, and 3, the victim must be consciously aware of the confinement at the time or be harmed by it. In committing the rule for false imprisonment to memory, I always want you to remember the mnemonic CIA. Suppose that one day you find yourself dragged into questioning by Gary, a man who claims he works for the CIA. Gary leads you into an interview room and locks you inside. Only it turns out Gary actually doesn't work for the CIA at all. Instead, he's just some maniac who locks people inside interview rooms. So remember CIA. That's C for constrains a person, I for intentionally, and A because the victim must be aware of the confinement. Let's talk about a few of the finer points with regard to false imprisonment here. First off, note that accidentally confining a party inside a locked room would not meet the intentionality standard. So if you accidentally confine someone inside a locked area, that wouldn't qualify for the intentional tort of false imprisonment. Next off, remember that if the party who has been confined has some sort of reasonable means of escape, they are not being false imprisoned. If they have an easily accessible door, or let's say there's a gate around them and there's an open gate behind them, that would not be a false imprisonment. Remember that if the defendant prevents a plaintiff from leaving in 3 directions, but the plaintiff is still free to leave in the 4th direction, there's been no false imprisonment. Example, Harry, as a practical joke, locks the front door of Ron's house from the outside so that Ron cannot open the door. There's no false imprisonment here if Ron can still leave the apartment or the house by way of the back door. Also keep in mind that there's been no confinement and no false imprisonment if a plaintiff has a reasonable means of escape. A means of escape would not be reasonable if 1, it is dangerous, 2, it represents a serious risk of embarrassment or discomfort, or 3, the plaintiff did not know of the means of escape. Keep in mind that false imprisonment can still be actionable even if the boundaries are intangible or the bounded area itself is very large or in motion somehow. Example, while Daniel is taking a shower after gym class, Harry steals all his clothing and all his towels. Daniel has been confined to the shower because he cannot leave without great embarrassment. This could be an example of false imprisonment. Another sort of strange example that pops up sometimes is that large area, that intangible area. For example, if Magnum threatens to kill Mousy if he leaves the city, Magnum would be liable for false imprisonment, despite the fact that the limitations of the city are sort of intangible here. Another example would be if Laverne locks Shirley in the trunk of her automobile and then drives around for hours, Laverne would be liable for false imprisonment. This has been our video on false imprisonment as tested on the bar exam and in law school. Be sure to check us out at barcastaudio.com for audio outlines, essay attack sheets, whatever you may need for bar prep or for law school prep. Check us out there. Until later, I will talk to you guys soon. Bye now.